In matters of truth and justice, there is no difference between large and small groups. For issues concerning the treatment of people, all are the same. There really can be no peace without justice. There can be no justice without truth. And there can be no truth unless someone rises up to tell the truth. You are welcome to today's episode of Naija News Series. Please kindly subscribe to the channel, hit the notification button for updates, give us a thumbs up, and leave a comment. The issue between the federal government of Nigeria and Nnamdi Kanu is getting interesting by the day. As a federal high court sitting in Umuahia, the Abia state capital, has ordered the federal government to pay the leader of the indigenous people of Biafra, Nnamdi Kanu, the sum of 500 million as damages following his illegal abduction and human rights abuse from Kenya. The court also ordered the federal government to return him to Kenya, from where he was extradited to Nigeria on June 19, 2021. The court, presided by Justice Anyandike, insisted that the extradition of Kanu from Kenya without recourse to the legal process was a flagrant abuse of his fundamental human rights. He held that the respondent failed to disprove the claim of the applicant that he was arrested, blindfolded, tortured, and chained to the ground for 8 days in Kenya before his extradition to Nigeria. Kanu, through his counsel, Aloy Ejimako, had approached the court challenging his extradition from Kenya on June 19, 2022. Ejimako told the court that the suit is sui generis of a special class and was primarily aimed at redressing the infamous unlawful expulsion or extraordinary retention of Kanu, which is a clear violation of his fundamental rights under Article 12(4) of the African Charter of Human and People's Rights, as well as Chapter 4 of the Nigerian Constitution. He said, in addition to the retention, I'm asking the court to redress the myriad violations that came with the retention, such as the torture, the unlawful detention, and the denial of the right to fair hearing, which is required by law before anybody can be expelled from one country to the other. You will recall that on January 19, 2022, the High Court of Abia State decided that portion of violation of Kanu's fundamental rights that occurred in 2017. Even as I made claims that bordered on retention, the court declined jurisdiction on grounds that retention, being related to extradition, lies within the exclusive jurisdiction of the Federal High Court. This is what informed my decision to initiate the suit before the Federal High Court. To be sure, the extraordinary retention of Nnamdi Kanu triggered myriad legal questions that cut across multiple jurisdictions in Nigeria and even triggered the international legal order to boot. In other words, the retention has expanded the matter of Kanu far beyond the realms of the Abuja trial and opened up new legal frontiers that must be ventilated to the hilt before other courts and tribunals within and without Nigeria. Thus, this very case before the Federal High Court in Umuahia is one of such that is aimed at seeking a definitive judicial pronouncement on the constitutionality of the extraordinary retention. The ones in the United Kingdom, Kenya, African Union, and the United Nations are in addition. I would like to seize this opportunity to express my profound appreciation to the highly competent and hardworking team of lawyers that I am leading in the prosecution of this complex suit. Special mention must be made of Barrister Patrick Agazia, Imfiyinwa Nwogu, Toshuku Arugbonye, Franklin Amandi, Ohaito Uwazie, and Mandela Umegborogu. For ease of reference and avoidance of any doubt, the following are the specific relief that I requested in the suit. Speaking to journalists shortly after the judgment, Ejimako said the judgment had shown that the court still remained the last hope for the common man. He called on the federal government to obey the court order and return Kanu to Kenya. In related developments, the embattled leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, has slammed a fresh 100 billion suit against the federal government over his continued detention despite the Court of Appeal judgment that ordered his release. Kanu, in the fundamental rights enforcement suit he filed through his team of lawyers led by Chief Mike Ozekome San and Ifeanyi Ejiofor, is praying the Federal High Court in Abuja to declare his continued detention in custody of the Department of State Service (DSS) as illegal, unlawful, oppressive, unconscionable, and unconstitutional. He maintained that his detention in disobedience to the appellate court's judgment violates his fundamental right to dignity of human person, personal liberty, and right to freedom of movement as guaranteed by Section 34, 35, 36, 39, and 41 of the 1999 Constitution as amended. Cited as first to fourth respondent in the suit marked FHC/ABJ/CS/1945/2022 at the Federal Republic of Nigeria, the Attorney General or the Federation, the State Security Service and its Director General. Specifically, the IPOB leader is, among other things, seeking an order of the High Court directing the respondent to unconditionally release him from their custody forthwith, as well as an order of injunction restraining the respondent, their agents, privies, assigned, or howsoever called, the further interfering with the applicant's rights and or dealing with the applicant in a manner inimical to his fundamental rights guaranteed by the 1999 Constitution of the Federal Republic of Nigeria as amended 2011. Compensatory and exemplary damages of 100 billion against the respondent for the gross violation of the applicant's fundamental rights to dignity of human person, personal liberty, and freedom of movement. Likewise, an order of this honorable court directing the respondents to tender an unreserved public apology to the applicants in 2 national dailies. Well guys, that's the news for now. Thanks for listening. Stay tuned to this channel for more news updates as it is hot. Bye.